Good morning, everyone. Those of you who are participating in the hearing room, thank you for being here. And also our virtual participants, thank you for participating in today's follow-up workshop on customer complaint matters. On September 16th, the clerk's office issued a notice of follow-up on customer complaint matters in docket number 2025-191A. And that notice mentions that the commission staff would conduct today's follow-up workshop to discuss issues specifically related to customer complaints. If we may now proceed to ask who's participating on behalf of the entities who are here today. Dominion Energy South Carolina, Incorporated.
Good morning, Ms. Boyd. I'm Chad Burgess. With me is Elizabeth Hutton. We're in-house corporate counsel for Dominion Energy South Carolina.
Okay.
And also with us today is Michael Anselmo from the law firm of McGuire Woods, who serves as the company's outside counsel. It's a pleasure to be here this morning. Appreciate you hosting us.
Thank you for being here too. Palmetto Broadband Coalition.
Good morning. Yes, Tracy Green here. I'm on behalf of Palmetto Broadband Coalition, and with me is Brad Wright.
Hi. Okay, and thank you, Mr. Green and Mr. Wright, for being here. Next is Water Company South Carolina Utilities.
Good morning, Charlie Terraney here for the Nexus Utilities.
Good morning, Mr. Terraney. Duke Energy Carolinas LLC and Duke Energy Progress LLC.
Good morning, Ms. Boyd. Tekla Henderson, and joining me for her first time at the commission is Ms. Bailey Jackson of Robinson Gray. We represent the companies. Thank you.
Was Ms. Jackson on a conference call? Yes. Well, this is your official in person. Nice to have you. Good to see you. Thank you for being here too. Carolinas Clean Energy Business Association.
Good morning. This is John Burns. I'm general counsel of CCBA. I'm mostly just going to be listening today. Thank you.
Okay. Thank you, Mr. Burns. Piedmont Natural Gas Company Incorporated.
Good morning, Jason Richardson with McGuire Woods, outside counsel for Piedmont Natural Gas.
Okay.
And happy to be here this morning.
Thank you, Mr. Richardson. Good to see you. South Carolina Office of Regulatory Staff.
Good morning, Ms. Boyd. Ben Muschin on behalf of ORS.
Thank you, Mr. Muschin. Okay, everyone. We can, unless someone has some statement that they want to make before we start this informal process, I'm going to begin with Dominion Energy South Carolina. I think they indicated first in the docket that they plan to participate, and then we'll proceed in the order that I just called each entity's name, unless someone has a better suggestion. All right, Mr. Anselmo.
Thank you, Ms. Boyd. As Chad said, we appreciate being here today. As you know, the company has mentioned this issue in a couple of our forums, and really do appreciate the commission and staff taking time to put this together. I'm going to be brief. The company really does appreciate the process that is outlined in the notice. A couple of high-level comments on it. Sort of the scope of what this would apply to. The company is of the opinion that it should apply to all customer complaint matters, regardless of customer class or representation. We've had great success using this actually hearing officer type process in a residential customer who was represented by a attorney. It worked well. That was sort of the genesis of the idea, frankly, was how efficiently that worked. And then we also had an industrial customer matter where we felt this type of process would have helped. And I think having a unified process for all customer classes or representation status would be the simplest and cleanest approach to that. Secondly, there's an issue related to timing on specifically between proposed steps 3 and 4 and 5, that window. Obviously, step 4 is the commission staff would need time to digest what I'll talk about later. In step 3, consider the issue and issue a report and recommendation, right? We're cognizant that you need time for that. And then also the commission would need time to review, set it for an agenda. But we would like to note that the company's experience is, despite the requirement that customers are supposed to keep paying for service, post-complaint service, unrelated to the challenged amount, the non-disputed portions, practice is they don't. And the reason is it's pretty much common knowledge. You file a complaint, you can't get terminated. So as we've told the commission in multiple hearings, those charges continue to accrue. What ultimately happens is if that debt cannot be collected, all other customers have to pick up that portion.
Mm-hmm.
So while we're appreciative that time will be needed in this, keeping it as compressed as possible is probably in the best interest of all customers. And then I'll note that step 2 in the notice says assigning the matter to the hearing examiner.
Mm-hmm.
That probably could be streamlined as part of the 30-day notice. Like, hey,
Yeah.
not really a separate step. I realize I think the company's initial letter said that, that was step 2, but we could probably streamline there. And then for step 3, this is evident from the notice and how it's drafted, but I think it's important to reiterate what the company is asking for the hearing officer to do is not make a 12B6 motion to dismiss determination.
Okay.
It is an actual treat as the commission does, treat the complaint as testimonial.
Mm-hmm.
The company will submit evidence. We call it a motion to dismiss because that's just been the practice because the orders that are later issued dismiss the complaint.
Mm-hmm.
But the company would file, in essence, a motion for ruling on the facts, for lack of a better term.
Okay.
Because let's say, for instance, a customer says, the company is charging me the wrong tariff rate on my electric service.
Okay.
That is sufficient to survive a motion to dismiss. The company would acknowledge that. But the company's records show, nope, they're a residential customer. They're taking service under rate 8. We file their bill
Mm-hmm.
showing it's rate 8, right?
Mm-hmm.
We should get a report and recommendation issued from a hearing officer saying the matter should be dismissed, right? So you have to be able to consider the facts. If this was step 3, if the commission envisions this as just a 12B6 determination, actually we don't need it.
Okay.
It would just be duplicative of current process. The intent is to give a robust process for customers, but streamline it for everybody to get an actual factual-based recommendation in the report and recommendation. So step 4 would say something to the effect of, I reviewed all the filings, including Dominion's records that they submitted, and either I recommend dismissal
Mm-hmm.
by the commission or for the commission to set a hearing.
Okay, now stop. Because
Yep.
you see where we staffed it, some staff, I can't blame it on everybody. When you use officer originally, thank you for your comments in the first, you remember the way
Mhm.
back when we started this process. And I was trying to, when I think of officer, I think of motions for confidential treatment. They're really not, that person's role is really not to rule on who won, basically, the
Mhm.
substance, right? So in yours, where you're mentioning officer, you do not envision or think that the report is the officer ruling on dispositive motions, like you just said.
No,
Okay.
We're cognizant of the fact that a hearing examiner can't make a dispositive ruling, but they can make a recommendation of
Okay.
for the commission to make that finding. So
Okay.
if I'm the hearing examiner and the example I just used says, no, the customer's being charged correctly, I've reviewed the file, my recommendation to the commission would be to issue an order dismissing the complaint.
Okay.
Mm.
And you're of the opinion too that, well, the complaint should be verified. I think that's on the form, so that's verified. And then the company's attorney files a response. Would any of the other part of the filing be verified by someone at the company?
The company's practice when we submit records or
Yeah.
make statements is to verify it. So
Mhm.
yes, we would do that
Okay.
in order to give a record that is that the hearing examiner would be able to make that recommendation that you and I just talked about.
Okay. Okay. All right.
Yep. And then again, the process looks exactly like what we had proposed earlier, but again, step 3 needs to be not did they plead something that will survive a motion to dismiss under 12B6. It's
Okay.
they made a filing with testimonial evidence. The company has provided testimonial evidence, and the recommendation is made by the hearing examiner for the commission either to dismiss it or set it for a hearing. And then the last thing I wanted to mention, I think Nexus Water Group raised this, is the commission already has the statutory authority to and the regulation in place to implement this procedure.
Mm-hmm.
So there is a question of how this actually would be implemented.
Yeah.
The company doesn't see the need for a regulation.
Mm-hmm.
I think the most convenient way would be for the commission to issue an order that sets forth, much like the notice, and then you have the pro se litigant guide on your website where you can say, here's the process, and just include the order.
Mm-hmm.
Because again, you already have the statutory authority to dispose of these complaints and the regulation in place to assign it to a hearing examiner.
Right. And I think what you're saying is the hearing could be a paper hearing, and because we don't anticipate, based on this version, witnesses having to appear, a witness or witnesses having to appear virtually or in person. It's all paper. Is that right?
That's exactly right for step 3. The company would strongly suggest that having a hearing in that stage would be would really gut the intent of what we're trying to do here, is streamline it, give it a very thorough review. And then, as you see in step 7, obviously, if you get to the point where a hearing is needed, we would do the old-fashioned pre-file testimony, witnesses would show up, and the hearing would be before the commission. But no, there would certainly, the company is not envisioning any type of in-person proceeding in the process involving the hearings.
Yeah. Okay.
Yeah, but all in all, really, this is we think, an excellent approach to giving full due process to all parties and streamlining the results that are needed in these cases.
Because ultimately, I think what you're saying is the commissioners are still making the ultimate decision, the final decision.
Absolutely.
About disposing of the complaint.
They would.
And you think that it should apply to everybody, all types of customers, this process would?
Yes.
Okay.
Yep. If you want an example of how this has worked,
Sure.
I'll cite our old case of Clyde Kennedy versus Dominion. The docket number escapes me off the top of my head, but we actually did this exact thing in front of Ms. Moser, I believe.
Okay.
The report and recommendation was issued to the commission recommending the ultimate result of dismissal of the complaint.
Mm-hmm.
The commission met, had the business meeting, they ruled on it, and the commission issued the final order that dismissed the complaint. But that's a really good example of how it operated.
But we had a hearing with Ms. Moser. Okay.
That's the only difference
okay.
that we would do it on paper this time
Right.
instead of the actual hearing.
Okay.
Mm-hmm.
Okay, got it. All right, Mr. Anselmo, thank you very much. Mr. Green? Oh, is it? There you go.
I'm glad I made Mr. Muschin laugh. I've accomplished my goal. Thank you for having this this morning. I appreciate the commission having you, Ms. Boyd, in doing this. I think from Palmetto Broadband Coalition's viewpoint, I think we agree with the idea behind this. I think the structure is a good idea. I think the only thing that I might add to what Mr. Anselmo said is maybe step 3 does say somewhere that a hearing is not required or may be resolved without a hearing, something like that.
Okay.
Just to make that clear and so that there's no surprise, I guess, to the probably the pro se complaint.
So it's something like the hearing is not required for the hearing examiner to review I can put that under that first bullet.
Yes, that's what I can
Yeah.
say. Some hearing but is not be held, but is not required, or something along those lines. I don't know, Michael, if you've got any language along those lines.
Yeah, I think I would be explicit and say that I'm just going to refer to it as it's referred to in the notice, that step 3, there will not be a hearing conducted. Because, again, nobody's going to miss out on a hearing if it goes in front of the commission, right? That is already covered, but I would just be explicit and say no hearing in step 3.
We wouldn't have a
No
problem.
problem. A hearing is not required. Okay, got it.
Because there will be a hearing or something if for some reason the motion is not granted.
That's right.
So yes, I agree with that. That's the only other comment we had.
Okay.
Again, thank you.
Thank you. All right. Mr. Terani?
All right. First of all, in general, we think the complaint procedures are great. It's a good step. I'll address Nexus's specific comments in a minute, but I want to go back to this step 3 question. I hate to be defining on what, but I don't think you ought to tie the hearing officer's hands. If a hearing is needed, it would be much more, in many cases, it would be much more efficient to have it in front of the hearing examiner rather than in front of the full commission. It would be cheaper and faster. Let the hearing officer, examiner, make that determination. If it's just a matter of some simple fact finding, we already do that in the telephone cases. I don't see why it couldn't be done here. The whole point is to do this faster and more efficiently. If we bump it to the commission when we don't need to, then there may be cases when you do. So I would make that point. My second point is what we said in our letter. There's been this question about whether or not this procedure could apply to water and sewer cases.
Yeah.
We believe it can. And the statute, I think, contemplates the ultimate decision made by the commission, and that's exactly what happens. The regulation, which has been there for a long time, probably as long as the statute, just gives the commission a means of gathering facts. I don't think the commission has to do all the fact gathering. Can you hear me?
Yes, sir, I can. I was writing what you
Okay.
said.
Good.
We have talked about this before. Mr.
Yeah.
Troy. That would be water, wastewater, and gas cases.
Correct.
Yes, sir. Okay. All right, did you have any other questions at this point, Mr. Jones?
No, ma'am. I think it's a good procedure. I would keep some flexibility in there so the commission can adapt, and the hearing examiner can adapt as needed. I agree with Mr. Anselmo. It could apply to all customer classes, but I guess I slightly disagree in that, the commission always has the authority to say, well, wait a minute, we want to hear this one.
Yeah.
Ourselves.
Yeah. Okay, I was going to ask, I have some proposed language I want to ask Mr. Anselmo and Mr. Green for the circle bullet point under step 3. If the language reads, a hearing is not required, but may be scheduled by, at the discretion of the hearing examiner, or the hearing examiner's discretion, if needed. Just wanted would like your.
We wouldn't have a problem with that.
Oh, okay.
I understand that position, and the company does too. These matters are expensive, and the costs are borne by other customers, right? And the reason we're suggesting a paper filing is to save those costs. Adding a second hearing really significantly, or the potential for a second hearing, greatly increases. We have witness prep, we have attorney time, we have internal company time, and the reason this is such an elegant solution, I think, as originally proposed with the concept of no hearing in step 3, is because in the event a hearing is needed, it will happen in front of the commission, where ultimately they are the ultimate decision maker, right? So if you add that other one, it's really defeating the purpose of the proposal, which was to streamline and give efficient results for both the company and the customer. I mean, they want it too, right?
Right.
So to the extent that the company has a position, we would stand by the no hearing in step 3.
All right. And do you think that if the hearing examiner thinks after reading the documents, look, I really think the commissioners need to schedule this for hearing. This is my report and recommendation. Schedule this for hearing before the commissioners. Is that kind of what he's saying?
It is, because I think it comes back to what I mentioned earlier. I think the hearing officer would have the ability to make 2 recommendations to the commission. One is the company's position factually is correct, there are no service issues, they comply with statutes, dismiss the complaint. Option 2 is, I think a hearing is needed. I think
Okay.
those are the two rulings that would come from the, or not rulings, recommendations would come from the report and recommendation.
Okay.
So, again, preserving the right for a hearing, and the hearing officer can do that. But in all actuality, the experience is once the factual record is laid there, you've seen the results. It's pretty consistently a dismissal of the complaint, regardless of which stage it is.
Mm-hmm.
So flexibility, while conceptually can make sense, would defeat the purpose of the streamlining of this.
Okay, I see.
Yeah.
So, Mr. Shirani, what about that idea? I'll come back to you, Mr. Green, just a second. If the hearing examiner, after reviewing the complaint, the answer, and the verified filing by the company, determines a hearing is needed, that be included in the report of the hearing examiner? So then there's one hearing before the commissioners.
I guess I just see this process differently. I mean,
Okay.
let me stress, the one thing I agree with is the default process should be the paper proceeding.
Okay. Okay.
But I don't believe if the hearing examiner sees the need for some fact finding, I don't think that necessarily translates into 2 hearings as Mr. Anselmo sees it. I think if the hearing examiner sees the need for some fact finding, the hearing examiner can do the fact finding, develop the record, make the recommendation, the commission can accept it. If the commission, even if the commission at that point gets to recommendations and says, you know, we need to hear more, they would still not just redo the hearing from the start. They would have a record. But
Okay.
I think in most cases, the hearing examiner would do exactly what we do, like in a CLAG case or something. They would just hear the record, develop it, make the recommendation, and we'd be done.
Okay.
And that, to me, would be a lot cheaper than going through the whole rigmarole of pre-file testimony and getting 7 commissioners together. I think the difference is getting it done in 3 months versus getting it done in 7 months.
Okay, Mr. Terrain, I'm not trying to get you to change your mind. Let me ask you this.
No,
Is there
it's fine.
another tool that the hearing examiner can use? Because I understand what you're saying. Maybe the hearing examiner has read the complaint, read the answer, read the verified statements, facts. Okay, I have more questions as the hearing examiner, more factual questions. Is there another way to receive that information? For example, what do they issue? They issue directives, hearing examiner directives. It says, look, company, I need this information. I need you to answer these questions, and I want you to file it verified. Do you think maybe that would help? And even to the complainant, it's questions.
Yeah.
Is that another way?
Absolutely.
Okay.
I think that would be a great way. Get them to supplement the record with verified statements if that's needed. Again, where I agree with everybody is the idea is to let this hearing examiner dispose of this thing quickly. So if they need to supplement the record with additional information, the default procedure always should be a written report.
All right.
But sometimes just getting everybody on a telephone hearing might save you 4 months of docket time.
Okay. So when you're thinking hearing, you're not necessarily seeing, we at the commission, for example, for the commissioners, of course, we like to see their faces because of the 15-minute rule. The complainant for other reasons, but the 15-minute rule. But in this scenario, as it relates to hearing examiners and complaint cases, what you're saying is, okay, maybe it's maybe the complainant doesn't have own a computer, but we can all engage in a telephone conference for additional fact gathering.
With the court reporter, I mean,
okay.
Again, I'm for flexibility.
All right.
And because I believe the flexibility will help us get rid of these things faster, and that's better for everybody. I doubt many complainants are eager to get in front of the commission.
Okay. You have any statements about that?
Ms. Boyd, I think
Yes,
your
sir.
idea on the directive if we make a submittal and the hearing examiner says, I have some questions, issue the directive, let us do it in writing, we'll respond. That is a nice way to streamline this.
Okay.
We're not intending to preclude evidence from coming into the record. We're just trying to do it in a more efficient manner, and that's really an efficient way to do it.
Okay.
Service is easy on the pro se litigants or represented litigants. Everybody does it in writing, posted in the DMS. I think it's a really nice way to do it. Our experience is coordinating schedules or even getting responses on status conference and things of that nature with customers is kind of virtually impossible. So the directive idea is very nice.
All right. Mr. Greenwood, do you have any thoughts?
No, I agree with that.
Okay.
Again, we don't, how many of our member companies don't really deal with this a whole lot, so
Right.
I don't think we feel strongly, and we understand the need for flexibility, but I think the discussion along the lines of that, I think we'd be perfectly fine with.
Okay.
That makes sense.
Okay. All right. Thank you. All right. We're going to move now. Mr. Trainee, do you have anything else? If not, I'm going to move on to Ms. Henderson and Ms. Jackson.
No.
Not right now?
No, ma'am, thank you.
Okay. Thank you.
No.
All right. Ms. Henderson?
Thank you, Ms. Boyd. A lot has already been shared, and we, in general, agree and appreciate the streamlined process that has been proposed by the Commission and its staff in regards to the steps that we've been talking through. Before I jump into the company's comments, I guess I should start by addressing what we've already discussed.
Okay.
We've heard from Dominion that they believe this procedure should apply to all customer complaints, and you probably have noted in our comments, we thought that it might be most beneficial for pro se residential customers to have this process applied to their litigation. Of course, that's based on our experience. And in the company's experience, when a customer is represented or when they're non-residential, those cases tend to be a little bit more complex. And to the extent that our own customer service and experiences teams haven't already had the opportunity to resolve those type of complaints, those being with people who are represented or non-residential customers behind the scenes before it even comes to the Commission, usually those need to be heard by the Commission because they're so complex. But we don't oppose Dominion's recommendation that they apply to all customers. It's just something that I wanted to note for you.
Okay.
In regards to this idea of the customer complaint process up into the hearing examiner stage being an entirely paper process, we would support that. But I really do like Charlie's comment about leaving flexibility for the hearing examiner. We've had great experiences with Ms. Mosier and others in regards to having hearings before hearing examiners, and usually those can be scheduled quicker. There's a lot less prep that goes into the witnesses because we're not prepping for a full commission hearing. And so to the extent that a hearing examiner would like additional information beyond the complaint that's been filed, our answer and our motion to dismiss, we would be fine having a hearing before a hearing examiner if that is the recommendation of the hearing examiner or whatever that looks like, that additional fact finding at that stage.
Okay.
Should the recommendation be, well, this is something that the Commission really needs to take up, it's more complex than what the hearing examiner feels like he or she needs to deal with on their own, we support that as well. I don't know if this is the appropriate time for us to jump into our comments, if you want to hear that as well.
Yes.
Well, I think Ms. Jackson may have a couple of things to share on that.
Okay.
Yes. Oops, sorry. So as to step one, the company's proposed a clarifying edit to that step one in our
Yes.
comments. And that was just to ensure that the ORS investigation contemplated by step one is the existing process where customer complaints aren't docketed until after ORS has had the opportunity to review it, make a finding, and then the customer can have a formal complaint and have that docketed by the Commission. In the company's experience, as Ms. Henderson said, they have a robust internal customer complaints team that works pretty closely with ORS, and that process has been very valuable in facilitating resolutions and preserving everyone's resources in getting a resolution that's beneficial to the customer and the company, everyone involved.
And Ms. Jackson, we can make that more transparent. That's what we do now.
Yes.
But I think I agree with you that the language should reflect that that's the current process. So thank you.
Yes. Yeah. Awesome. And then moving on a little bit in our comments, sorry. So the companies also recommended maybe adding between steps 4 and 5 the opportunity for the parties to comment on or object to the hearing officer's or hearing examiner's recommendation. And we feel that that squares with federal practice, where a magistrate judge will evaluate, issue a recommendation or report, and then the district judge has final say, just like the commission has final say on the dispositive motion, the actual resolution of the customer complaint.
May I ask you?
Yes, ma'am.
Do you
Yeah.
have a recommended number of days for that? Like 10 days or 10 business days, or had you thought about that?
I haven't, but we would support 10.
Okay.
Yeah. And notably, that federal rule, it's in federal practice, it's Rule 72B, and it doesn't allow for a reply. So everyone gets one bite at the apple of
All right.
one objection, one reply. It won't go on into perpetuity.
Thank you.
Yeah, and then we also believe that under 103-804F and 103-850 or 841, the hearing examiner has that ability to receive those comments or objections on their report.
Okay. Thank you.
And the final thing is, we also had the question of where these will be housed if they're adopted. Would it be a regulation? Would it go to the pro se litigant guide or be otherwise guidance? But that's all the
And
companies
thank
have.
you for that. I hadn't
Yeah.
thought. I don't think another regulation is needed, but I do think a commission order, or even in the guide, or just a procedure but we do need to publish this, have it available on our website. I think the pro se litigant guide is an excellent suggestion for us to definitely, it should be probably the second page or third page after the table of contents.
Yes.
So thank you.
Yeah, and Ms. Henderson, do you have anything? And that
That's
is
all right
all
now.
from the companies. Yes, ma'am.
Thank you.
Yeah.
All right. Mr. Burns, have you thought that you may have some comments at this time?
I'm fine, thank you. No comments from CC, but thank you very much.
Okay, thank you. All right, let's see. Mr. Richardson.
Yes, Ms. Boyd, thank you for, again, allowing us to participate here. Piedmont doesn't interact with this process a whole lot, but certainly appreciates everybody's comments and supports the utilities. Duke companies and Dominion's company and everybody else's comments regarding streamlining this process. Anything that can make this more efficient for the commission, litigants to come before it, and the utilities would be helpful.
Okay. Thank you. Mr. Mustian.
Just to flog this deceased equine a little further. So, do you like that one? Thanks. So I agree with everything that's been said. I tend to agree with Charlie to go back to the hearing piece of it. I don't know that I would entirely take that off the table. I get streamlining the process. I get all that. What's sticking in my head is, and I think we all are looking at it through the lens of residential customer complaints, which is obviously the bulk of the complaint proceedings. There are sometimes, commercial customer complaints, and those can be more involved. And so as I, read this would apply to that as well. So, I can envision a time where a hearing examiner may say, hey, I need some additional information. You certainly could get that through, written requests or something in that nature. It could be that maybe that isn't sufficient, and then that leaves the hearing examiner to issuing a report saying, I can't make a recommendation, and then you got to go through the whole hearing. So, I tend to agree with Charlie that if the hearing examiner could have a brief hearing, whatever, that may streamline that to some extent. And so maybe you might consider a hearing will not be held unless the hearing examiner determines it is necessary to completing the report or issuing the report or something of that nature. So I think there's many ways to address it. I think parties have given good suggestions for the commission to consider. So I just throw that out there. The other comment that we had was on steps, I think it's steps 4 through 6 or 7. 6. And I realize this is just kind of a draft framework. Our recommendation would be that the commission consider establishing some standard timelines for when the report would be compiled and issued. I'm sure you could put in some language that that could be extended or whatever, but to give the customer and the company some a schedule under which this will be completed, so that it doesn't drag out too far, and I think that would get to the ultimate goal of trying to streamline the process. So would suggest that. And then in step 7, and again, I know this is just a framework. It says if the commission voted to reject a report that the recommended dismissal of a complaint, it would return to the hearing examiner. Also, it could be that the hearing examiner says, I recommend that the commission hold a full hearing. And so I think that's kind of implicit in some of this, and then that would roll into kind of the normal complaint hearing process. But when that's being fleshed out, it's, we all kind of understand that more than likely in a lot of these cases, the hearing examiner may recommend the dismissal. It can also be that they may say, yeah, there's something there, we think it needs to go forward. So I would just at least consider that.
Okay, so if you would walk with me, please, on step 7. So if the commission voted to reject the report says, okay, dismiss the complaint.
Yeah, so under that scenario, the hearing examiner has said, I agree, this complaint needs to be dismissed. The commission looks at it and says, no, we disagree. Okay. And then it goes back to the hearing examiner to oversee the completion of all the testimony deadlines and blah, blah, blah. It could be that the hearing examiner says, issues a report recommending the commission hear this matter. Okay. And so I think that's kind of implicit. But if this is going to go into a regulation, I think you may just want to consider fleshing some of that out a little bit.
Okay, thank you, Mr. Mushroom. All right. So we've done our first round. I'm just going to ask at this point if you have any additional comments, everyone. Mr. Anselmo, I'll start with you and just none. Okay, thank you. Mr. Green, none at this time. Mr. Terani?
Let it be noted that I agree with Ben.
You agree, Ben? On
This is a red letter day. I love it. Can we record this for posterity?
Let's see, Ms. Henderson and Ms. Jackson. None. Okay, Mr. Burns.
I'm just glad that I was here to see Charles and Ben agree.
Mr. Richardson. No none. Okay, and Mr. Mushroom. All right, so. The only other next steps I know to do is kind of refine this, everybody, and based on the comments received today, and then maybe we can the clerk's office can just ask for any additional written comments before we present it to the commissioners for certain modifications, if that's okay. I don't know that we need another forum like this after you see the revisions. For example, I'll use Ms. Jackson's example, where in step 1 we would amend the language there to include that the complaint will be docketed after first confirming the Office of Regulatory Staff has concluded its investigation. Those are the type changes I'm talking about. And then we'll ask you to respond in writing if you see anything else that we need to work on. And then I would address it with the commissioners, and that would have to be at a commission business meeting. Okay? All right. Thank you, everyone, for being here today.
Thank you.
And we'll see you soon.
Thank you.
Thank you.